Hello, hi, and welcome to this in the latest edition of the series of Renters' Rights webinars with us, the DPS, along with the Guild and Letting of Management. I'm very pleased to have Susie joining me again today. How are you doing, Susie? You okay?
Yes, I'm good. Very much looking forward to this one today.
Absolutely, a lot of content to cover, a lot of interesting twists and turns, no doubt. So thank you so much for joining today. For those of you who will be asking about recording in terms of these sessions, they will be available for you to share. So we'll give you more details at the end, but without further ado, we're talking about the overview of the Assured Periodic Tenancy. So I shall pass over to you, Susie.
Thank you, Dave. As I said before, we actually came online. We're going to look at something very, very technical. We're not going to be talking about kittens or pets or anything in that vein. The Assured Periodic Tenancy is something that's going to be very, very new. So I just want to go through the objectives for this particular session. We have talked throughout some of the sessions that many of you have attended about different elements of the Renters' Rights Act. And the focus in this session is going to be around documents and key paperwork. So we really want you to make sure that you correctly navigate the changes. And we're working towards and leading up to the 1st of May when these changes will be implemented. So we'll go through them, not in a fast or panicky way, but we'll think very carefully about what needs to be done. So what's the purpose of this session? I wanted to really think very carefully about new legal duties. You could effectively say that the whole of the Renters' Rights Act itself is a new legal statutory duty for landlords and obviously for tenants, because I think people keep forgetting that, you know, there are two sides to this coin that is the Renters' Rights Act. So we're going to look and focus on paperwork and key information. We want to think about and be able to demonstrate when, how, and to whom this information must be given. And obviously, you know, our target audience throughout these sessions will either be landlords, letting agents, and in some respects, maybe we'll have tenants who join us. So we want to understand what those statutory obligations are, and obviously why. Now, the whole point of thinking about each element of the Renters' Rights Act is to minimise risk. We don't want to be in a position where landlords, letting agents face fines, complaints, and are on the receiving end of regulatory action. So that's the other element, that's the whole point of these sessions, to have a really, really good understanding of what these obligations are, but also to minimise the risk for you. So time is of the essence, one of my favourite legal sayings. If you're interested, you can look that up somewhere. I'm sure AI will tell you exactly what that means, but it is of the essence. It's really important that we just very quickly revisit the fact that the Renters' Rights Act will be implemented in 3 phases, and we are very much in this session and the other sessions that you've attended and future sessions, we are focusing on phase 1. It's the 1st of May that we're thinking about, very key date for us, when many of the elements that we've been discussing throughout these sessions will actually be implemented. And this will lead you very, very easily to one of the key elements. Now, we've talked about a white paper. The white paper sat under a previous government and effectively was published by a previous government. And the white paper was all about levelling up. It was published in 2019. The headline at that point, one of the key things that was picked up by journalists, trade press, national press, the BBC, Sky TV, was the fact that Section 21 would be abolished. That was the lead headline and has been for the last 6 years. And the irony is it actually hasn't happened yet. So as a result of abolishing Section 21 and its correct technical term, if you like, Form 6A, means that fixed term tenancies will also be abolished. And we've been used to fixed term tenancies for quite a long time. We have a start date, an end date. We know what the term is. Could be 6 months, 12 months, 18 months, 36 months. So they will be no longer as from the 1st of May. So no more fixed term tenancies. And just for clarity, just to kind of reiterate, some of the things that we've talked about before is that the legislation, the Renters' Rights Act, applies to all assured short-hold tenancies, which we're very, very used to. But the abbreviated version is AST, and assured tenancies, which have been around a lot longer than the AST. So those tenancies effectively need to be converted in some shape or form. And this will happen on the 1st of May 2026. All tenancies, regardless of when the tenancy was created, if it's an AST or an assured tenancy, will become a periodic tenancy on or after that date. And I'll explain why I've said on and after. The new rules apply to new tenancies. So one of the questions that we are asked on a frequent basis is if my tenancy starts on the 1st of May, when does it end? When is the end date? There is no end date. So effectively, every tenancy that is created in England on or after the 1st of May 2026 will be an assured periodic tenancy. So start date, no end date. Your existing tenancies also, one of the key dates for us will be the start date of that tenancy. Okay, so these things are really extremely important. I'm touching and going through the tip of the iceberg, but if you start drilling down into the detail, it is quite technical. And obviously, you know, not just yourselves, you are key stakeholders effectively in this, not just DPS and the other deposit schemes, but solicitors, legal firms, law commission, everybody is looking at this in great detail, okay? And we look at the legal specialists because they have a much more in-depth understanding, especially when things go wrong. So we have new legislation coming. That means there will be new terminology. So AST, assured tenancy, will no longer exist and the terminology will change. So we're focusing in this session on 3 elements, even though the title of the webinar is an overview of the assured periodic tenancy. But in conjunction to that, there are 2 legal duties that are extremely important. And the terminology that we're going to think about is the information sheet and the written statement of terms and information. And just for ease, I'll refer to that one as the written statement. Okay, so 3 new types of terminology. So what is this information sheet? Huge amount of discussion around this. You've probably read blogs, been on other webinars, looked at forums, taken part in Q&As, lots of information. The information around this information sheet was actually published at the end of January 2026 in the form of a statutory instrument. Now, at the time of this webinar, the information sheet has not been published and will be published by the government in March 2026. And you're probably thinking, but it is March 2026. But hopefully in the last 2 weeks of March, we will have this template. So we have existing tenancies. We have existing tenants. we have existing guarantors, and their existing tenancies need to be converted to an assured periodic tenancy. How does that happen? Through the issuance of an information sheet. The information sheet will be published by the government. Hopefully, by the time you've listened to this, you will have familiarised yourself with the information sheet. There are timeframes that adhere to this information sheet. The landlord, and if you have an agent who acts on your behalf, will have to issue that information sheet starting the 1st of May 2026 with a cut-off date of the 31st of May 2026. So we have a window, and that's why I use the phrase time is of the essence. Okay, so it's really, really important that we adhere to those timeframes. The information sheet must be given to all the named tenants on that tenancy. Okay, so I really want you to think very carefully about this, and I'm going to give you a very easy example. We have 3 joint tenants, all named on a joint and several AST. They moved into the property in 2023. They're not going anywhere. So on the 1st of May, each of those 3 tenants, all named on the information sheet, must get a copy of the information sheet. You can't rely on one tenant to give the information sheet to the other 2. So can you please be very mindful that you do this thoroughly and diligently. The other thing is your guarantors. We have obviously a lot of tenants in England who have guarantors for lots of different reasons. The guarantor has an interest in that tenancy. They are not the tenant, but they carry liability. So we need to make sure that the guarantor is aware of what is being served on the tenant, and they also receive a copy of the information sheet. It won't have their name on it, but you'll put a covering letter together just to explain what this document is for and why. The government have said that the information sheet can be served on tenants electronically, so via email. A lot of letting agents use e-signing platforms that are often linked up to their software systems. So that is one option. The other option is hard copy format. So effectively, you prepare the information sheet, maybe not put a covering letter with that information sheet, and then put it into an envelope, and then either serve it by hand and or first class post with a certificate of posting. Now, just on that point, you need to prove you sent this information sheet. You need to prove you served the information sheet. Okay, that is really important. What the tenant then says, I didn't receive it, you never sent it to me, that's for them to prove. But you must be diligent and you must show that you served the document. Doesn't need to be signed. A lot of letting agents are very belts and braces about signatures, but that's where an e-signing platform is really useful, because you can track how many times the recipient opened the document and so on. Okay, and that would denote that it has actually been received. So think very carefully about service, but also think very carefully about the fact that the government, you shouldn't be buying this document. That's not, that definitely shouldn't happen. This will be issued by the government, and there'll be a lot of guidance and a lot of information. And equally, one of the things I also want you to think about is when this document becomes available, the government may advise that you can serve this in advance of the 1st of May. Be very careful if you do serve this before the 1st of May, because that would mean that you've actually converted your AST and assured tenancy to an assured periodic. And if you wanted to serve notice on an existing tenancy, then that will cause a problem. Okay, so be very, very mindful of that. The other point that I want you to bear in mind is April would be a good time because the government are issuing guidance for tenants. Would be good for you to take that opportunity to communicate that changes are afoot to your tenants. It's a very customer care approach to take, so that on the 1st of May, the tenant doesn't receive this information sheet and thinks, well, what is this? I have absolutely no idea why this has been sent to me. So do think about communicating with tenants. I think it's a really good proactive approach. So the information sheet will advise existing tenants and their guarantors that the contract is now an assured periodic tenancy. You do not need to issue a new contract. Okay, basically you've got pre-existing contracts. There are millions of them in England. Remember, there are 9 million tenants. Okay, and I can't give you the exact figure of how many of those are actually in England, but let's say there were 7 million or 7.5. That's a lot of paperwork. Okay, so we're issuing this information sheet and we're telling them that certain contract terms will be new as per the Renters' Rights Act. They will also have to comply with the new rules, and this is why I think it's important, whilst the government will be issuing guidance and information for tenants in April 2026, it's good for you to engage in that. You know your tenants, you have connections with your tenants, you can communicate with them. So make them aware that this is coming, but the information will be very in-depth on that information sheet. The Renters' Rights Act will also change the way that the tenancy is managed. So rent increases and rent reviews, service of notice by a tenant, service of notice and the reliance on Section 8 by a landlord, lots of rules, new rules in relation to rents, obviously rules in relation to pets. So this is a way of actually bringing together the information and telling the tenant that this will impact their rights and also landlord rights. Okay, and I keep hearing that this legislation is very much in favour of landlords, and obviously it depends what your point of view is, but there are also tenants in existence, so tenants do also have to adhere by these new rules. So that is the first new legal duty. It's the information sheet. Just to remind you that the information sheet is for existing tenants where tenancies were and have been created before the 1st of May 2026. So what about our new tenancies? So this relates to the written statement of terms and information. This is a legal duty that is imposed on landlords from the 1st of May 2026. Now, there is a paragraph in here that I really want to focus on, and this has been drawn down from the statutory instrument, and then I'm going to clarify a few things for you. So the purpose of this new legal duty, this written statement, also a document that will be in the form of a template, and it will be issued by the government. Okay, it's not something that you should be buying, and I stress that because you should have that information available to you through the government website. Now, the key to this is that the tenant will be properly informed about the terms of the tenancy. Effectively, this is a summary of the terms that they will commit to before they sign their periodic tenancy. Okay, so that's why I've highlighted and put in bold the word before, and we're going to talk about what the implications, the practical elements of that are. Why have the government put this in place? Now, if you are aware of legislation in Wales, and we have lots of experts who know that legislation far better than I do, you will understand that Wales also has a written statement. The purpose of this is so that the terms of the contract that the tenant will enter into are very clear. So that means there's no ambiguity, there's no grey area, there's no misunderstanding, and that should increase transparency. No hidden or unfair terms. None of the core terms are hidden. Everything's up front and in writing, and therefore hopefully that should have the ability for us to have a reduction in disputes, because we've got a clear record in that written statement of what was agreed, okay, before the tenant has entered into their contract. This standardises practice. There's been a lot of discussion about the Renters' Rights Act, lots of different elements that people are very upset about. I would say landlords are upset about them. Some tenants are very upset. Tenant groups, professional organisations representing landlords. But what I think a lot of people are missing, and this is really, really important, this becomes a standardised practice, okay? The legal duty is to make sure that contract terms are in writing. No informal approach to a tenancy, okay? No writing everything down on a post-it note and saying, there you go, this is your tenancy, or a verbal agreement, okay? That has to stop, because this protects both parties. What did the landlord offer? What did they agree to? What did the tenant accept? What did they agree to? Very straightforward. Okay, so I quite like this approach. It's kind of bringing the pre-tenancy terms together, having a summary, and everybody is very clear about what to expect. So this, again, and I keep reiterating, the written statement relates to tenancies that are created on or after the 1st of May. Okay, so it applies to verbal agreements that were entered into before the 1st of May. So if, and we come across these not very often, but they do pop up, if somebody's entered into a verbal contract, let's say with a friend, or, you know, somebody that they've done a favour for, that person needs to receive not an information sheet, but a written statement, because they didn't have anything in writing before. The draft instrument that people keep confusing with the written statement was published in January, and that kind of gives you an overview of what will be included in this written statement. And there's discussion around certain points, so I'm going to go through these with you. The first is the name and contact details of the parties, so landlords, tenants, everybody needs to be named on the written statement. Now, one of the things that's popped up has been the address of the landlord for service of notice by the tenant, and that's under section 48. So that is really very, very important, because if a tenant needs to serve notice, where will they serve that notice to? And managing agents, letting agents have been very involved in this, because often they manage the property on behalf of their landlord and notice is served to them. So we don't want a repeat of prescribed information from 2007, where originally it was only the landlord that could be named on prescribed information, and that changed in 2012. So we don't want a repeat of that. We hope that this document will be easy to use for landlords and for their letting agents. Okay, so names and details are very key. Obviously, the property, we need the property address, being let, start date of the tenancy, but no end date. Okay, if we go into detail, which I'm not going to go into detail on this, Dave and I had a discussion about this yesterday. Effectively, we talked about a periodic tenancy comes to an end every month, but there won't be an end date, effectively. Point 3, very straightforward, rent, the rent amount. Obviously, rent frequency is going to be monthly because this is a periodic tenancy. The security deposit, please do not confuse the written statement with information relating to the holding deposit. That happens way before. Okay, so keep that part separate. So this relates to rent amount, deposit amount, and obviously we know that under the Tenant Fees Act, we've got criteria we've been abiding by since 2019. So everybody's aware about the 5 or 6 week cap. Rent increase mechanism. How will rent be increased under or reviewed even under the Renters' Rights Act? And then one of the bullet points on screen under point 3 is really, really important, is whether the rent includes utilities, council tax, television license, communication services. Okay, so that needs to be really clear. And I often see a lot of mistakes around that. So I think this is why it's really quite useful to have these terms in advance and everybody's very clear. Tenant notice period, I would want that to be, you know, front and center, because remember, there's always been confusion about tenants serving notice, the effluxion of time, tenants being able to walk away at the end of a fixed term tenancy. That will no longer be relevant, but the tenant notice period, 2 months notice to be served in line with the rent date, anniversary date. Now, I just want to caveat that, because that sits under another piece of legislation which is being amended, and we just need to make sure that we have clarity that it is rent date, anniversary date. Point 5 is reference to how the landlord can obtain possession. I really want to stress that I am really totally against people talking about Section 8s and Section 21s as eviction notices. They are not eviction notices. Okay, Section 21 has never been an eviction notice. So Section 8 also is not an eviction notice. It's a notice that enables a landlord to obtain possession, but unlike a Section 21, you have to have a reason. Okay, so this will clarify that the landlord can use Section 8 notice, the new version, with the grounds for possession. Okay, so the tenant is clear that potentially, for lots of different reasons, the landlord could ultimately serve notice. Safety matters on point 6, and that could be read in 2 ways, that safety does matter, or this relates to safety matters, and the landlord's statutory obligations, okay, which always sit at the very forefront of the landlord's duty of care. And then any additional information. So I've just given you a couple of examples. Reasonable adjustments for a tenant that may have a disability, and then consent granted to keep a pet along with the relevant terms. Okay, so there's some very key points, and the written statement, I think, will be very, very easy to follow. Again, as with the information sheet, the written statement will be published by the government and provide a guideline. Now, this is something really, really important. So I'm going to deliberately go very slow here, and I've been reading a lot online and having a lot of discussions with letting agents and landlords. The written statement can be issued to the tenant as a standalone document. Okay, so it can be issued to the tenant before they receive the assured periodic tenancy, or it can be included within the assured periodic tenancy. So effectively, it's putting those 2 things together. Which option is best? Well, that's entirely up to you and the advice and the guidance that you follow. The written statement is basically saying to the tenant, these are the key terms, the summary of what's in the contract, but an abridged version, a shorter version. The assured periodic tenancy is the detail. Okay, so it could be that you combine this as one document, and the first few pages are the written statement, and it's very clear. Written statement of terms and information, and underneath it will say something like pursuant to whichever section of the Renters' Rights Act 2025. And then underneath that, you'll carry on, and it will be all the terms in great detail of that assured periodic tenancy. Okay, so think about that really carefully. Are there pros and cons? And I'm sure that you will ask that. I think it depends on the way that you run your property business. The benefit of issuing the written statement first is that if there are any errors, the tenant or the landlord can pick up on those. And one of the most common things, well, I can think of many common things that are missed, but the landlord promised furniture and there isn't any, and it's not even in writing. The landlord promised white goods. The landlord said there's a parking permit that comes with this property and it's not been put in writing. It's that kind of thing. And I think before the tenant enters into the contract, everybody can check that those terms are really clear, sign date, and then they'll sign their contract. So, but that is entirely up to you, okay? And if you're unsure, ask the question, obtain legal advice, and see what is best for your business. From my point of view, which do I prefer? I don't think I've said, but I quite like written statement first, contract second. But like I said, it's entirely up to you. Okay, so this assured periodic tenancy. Big document. You may source your paperwork from your solicitors, from specialists who specialize in providing legal paperwork. You'll find a lot of those online, maybe from your software provider. So software providers, and this is not just letting agents, but landlords who have bigger portfolios may be provided with paperwork through their software provider. I really want to stress something. Please do not use AI. I mean, I can't stop you from using AI. You might think, oh, this is a good idea. I'll put all this information into AI and it will generate an assured periodic tenancy for me. What's the danger of that? Well, I don't know how accurate AI is. I can't tell you. I do have the odd argument with ChatGPT when I'm asking it questions and they come out wrong. But that's entirely up to you. But that's something that I think, you know, any legal practitioner would most definitely not advise. So think really carefully about where you get your paperwork. So current terms under an AST, we have an end date, we have a rent increase clause, we have reference to Section 21 and service of that Section 21, and then what will happen if the tenant doesn't vacate, break clauses, refusal of pets, and then currently I've put no reference, but we do have reference to percentages for rent review, CPI, RPI, and so on. References to advance rent and so on. So they're the current terms that are very, very common in most contracts up and down the country. The new terms within the assured periodic tenancy, well, it's an assured periodic. There shouldn't be anything on that contract that talks about an AST. Monthly rent, monthly tenancy period, rent increased annually, reference to the Section 8 grounds, because obviously we're not going to refer to Section 21. Pet clauses where applicable. So if you've given consent, you'll have a set of pet clauses within a pet policy, tenant notice period in line with the rent date, anniversary date, and then all the references that will have amended certain pieces of legislation relating to the Renters' Rights Act. Okay, so you know that you're using, hopefully, the right document. So key points for you to think about. I really want you to think about the fact that all your existing tenants and guarantors will receive an information sheet from the 1st of May 2026. Really very, very important that the cut-off for the information sheet is the 31st of May 2026. Okay, so that's a key month for the private rented sector. All new tenants, these brand new tenancies, will receive a written statement of information, and as I call it, it's an overview, a summary of the key terms in the contract. And remember what I said, you can either opt, and this is your decision, to issue the written statement first. Here are your terms. Is everybody happy? Sign here, date here, and then here's your contract. Or you can combine the two. Any contract that was created verbally, so it's an existing contract, but there's nothing, never has been anything in writing, make sure that those tenants also receive a written statement of information, but not the information sheet. And then obviously, as I've said, every single tenancy becomes an assured periodic on the 1st of May. I'm very much into planning. I like to know what I'm doing, how I'm doing it, when my deadlines are, am I up to date? And that should apply to you as well. Your job is probably harder than mine because you have to implement what we're talking about. So you need a strategy, and the strategy can be in the form of a checklist. You can keep going back over these webinars and thinking, okay, for this particular element of the Renters' Rights Act, have I done everything that we discussed in the webinar? And you can even draw your checklist and your strategy from those webinars. So point one, stay informed. It's a lot to absorb, a huge amount of information, 226 pages of legislation. I think to date, probably 22, 23 guides, but those guides keep being updated. Okay, so attend webinars, events, lots of events available. Seek up-to-date and accurate information, because you're going to hear, even on here, you may think, well, I'm sure I heard something different on a different webinar or a different event, but that is very important because everybody has the same information. It may be just the way that it's been explained to you. Now, point two is something that I'm a really big fan of, and point three as well. Where do you think my go-to would be? Where do you think I get my information? I'm very lucky that I work very closely with a barrister, and then I look to some very, very, very expert solicitors. Okay, but my point of reference, as with them, is .gov.uk website. So you can sign up for alerts, and the alert will come in, and it often asks, do you want an alert daily or weekly or monthly? But the minute there's a change, it will hit your email inbox, and then you'll know that something has been amended, updated, changed, or published. And that is really useful for you because it's coming from the horse's mouth. Point three, this is very important because the government will publish the forms that you require. Now, this became extremely, extremely important during the pandemic, in between the different lockdowns, and this was our go-to. People don't like to think that government departments face challenges, but it was challenging for them to kind of keep on top of those changes. So any new forms and documents will be published by the government. And I've just given you a little list. Section 8, Section 13, both of those are two very, very key notices. Alongside those notices, guidance notes, okay, the methods that you need to use to serve those documents. Okay, so it will provide you with a huge amount of information. Also, the information sheet will be published by the government, so that's important. the written statement of information and terms, and something that only I think, and I'm sure somebody will correct me if I'm wrong, but a model tenancy agreement, Assured Shorthold Tenancy, was published in 2019, and that's I've seen being used by a lot of landlords. So they'll provide an a model Assured Periodic Tenancy that you can use for reference, or you can actually use. So there's a lot out there, but I would make my point of reference always the .gov.uk website. Okay, and even if you can't find it, you can do a quick search on a search engine and type in .gov.uk and Renters' Rights Act 2025, and then you'll find what you need. Point 4, we have all that information. So we've downloaded either in PDF format, we've printed it off. Can you please take time to read the information? And I think this is where, you know, we talk about the content and 226 pages of legislation, which sounds quite huge, but it actually isn't compared to some other pieces of legislation. It's not the biggest, but it is one of the most pivotal. So take your time in the next 6 weeks, months to set time aside, read the guidance, read the template documents, and familiarize yourselves with them, because this is not just written for you, as in the legislation, but you are the practitioners, you are the landlords, you are the letting agents. You need to know, okay, because you'll get questions from tenants, from other landlords, from, you know, stakeholders. So this is very important for you. Point 5 is crucial, and if I was highlighting anything, it would be point 5. Ensure that you do not miss these statutory deadlines. I keep telling people, and they're not happy when I say this, that May 2026 is the shortest working month, 19 working days. Okay, 2 bank holidays. Wasn't a great idea to launch this in May, but it is what it is, and you have to comply. Okay, so all annual leave is cancelled in May. Joking, but that could be a possibility. Okay, so this has to be done, you know, in preparation. My school of thought is the information sheet. Once it's published, familiarize yourself with it, know what you need to do, and plan when you're going to send that out and how. Equally, the written statement, you can prepare in advance for tenancies that are going to begin on the 1st of May onwards, so you can prepare information in advance, but you need to read those documents. It's not enough just to say I downloaded them. And point 6, do not panic. Hopefully I've given you an overview that should make you feel quite calm and prepared. The rules are very clear. Okay, we have timeframes to adhere to. We have new legal duties to adhere to. We know what those new legal duties are, and we have to implement them. And I would be very careful if I was thinking beyond the 31st of May. Remember, if you do not meet that deadline of the 31st of May for your information sheet, I hasten to add, and I do not want to say this, but the fact remains is that landlords will face penalties. And we've talked about this on the other sessions, that the enforcement is not for the faint-hearted. Okay, so be really clear about what you need to do and how. There we are. So hopefully that has been useful. Thank you so much for taking the time to watch this, and I'm sure you'll have lots of questions, but take a very, very calm and proactive approach as opposed to reactive to these new changes.
Amazing. Thank you so much, Susie. I like the strategic plan. Point 6, do not panic. Do not panic. So all that information is so useful, as always. I'm very grateful for you joining. For everybody watching along today, a reminder, this content does not belong to the DPS. It's the Guild of Letting and Management, and Susie and our amazing team pulling this together. So if you'd like to know more, if you have any questions, feel free to head over to the Guild of Letting and Management's website or drop them an email or a call and hear about their other training courses. From a DPS perspective, as always, anything to do with end of tenancy disputes, we'll have some webinars coming up soon about that, and any training and guidance you may need from our point of view. And we've got lots of helpful landing pages. So the government website, there is also information there surrounding the Renters' Rights Act, and there's a link just on our page there. So all that's left for me to say is, Susie, thank you so much. Fantastic information, always great to catch up with you. Thanks, Susie.